Good morning, parties. I'd like to get on the record. September 24, 2018, Southern Room B, 9:30 start. A specially constituted docket with respect to the hearing of 4 related matters, all pertaining to 99 East Avenue South, Hamilton, Unit 2, and those would be SOL 84218-17, SOT 77620-16, SOT 80393-17, and SOT 91682-18. My name is Sean Henry, and
my name is Christina De Leon.
We are members of the board. Parties have attended before each of us on, I think, at least one of these matters for each member. Given the fact that these matters relate to the same tenancy and that there may be a factual overlap with respect to the contents of these variety of applications, the board deemed it appropriate to combine to hold the hearing with respect to all these matters at the same time and to strike a panel with respect to these consisting of the 2 members originally assigned to at least some of these matters. Mm-hmm. Now, if we could ask the parties to identify themselves at this table.
Name for the record, Yakni, Y-A-K-H-N-I, initial B, paralegal for the landlord who is before the court.
Thank you so much.
John Serino, the landlord.
Thank you very much. And at this table?
Paul Peter Bosch. I'm a tenant and normally known by my middle name, Peter.
Okay, thank you. And hello, ma'am. Are you able to identify yourself? Hello, Miss Ball. And you are a tenant as well, eh? Now, Miss Ball, you're obviously in some physical distress. I don't know if you're in a position to articulate for me what, if anything, I can do or we can do to accommodate your circumstance. Board staff advised that moments ago, before the start of the hearing, that you were so ill that you were vomiting into a bucket that we provided you in this room. Is that right? Okay. Did you want Mr. Bosch to speak for you here with respect to what, if anything, we need do in relation to your physical circumstance, Mr. Bosch?
Yes. We'd like to request an adjournment on the grounds that Ms. Ball is not able to properly participate in the hearing.
Why?
She's physically ill, has a migraine, is vomiting, and she's not able to properly participate as a witness either. There are some preliminary matters I think we can get out of the way.
We're not quite there yet. Does that conclude the reasoning for your review for your adjournment request? Anything else?
No, that's it. She's just not able to properly participate in the hearings.
Okay. Ma'am, any questions for the tenants with respect to their request to adjourn?
Chairman Henry, I did have a discussion with Mr. Bosch earlier. Mm-hmm. He was requesting consent. Mm-hmm. I recognize that Ms. Ball is in some distress. Yes. I've spoken with the landlord. We do not have consent, and that's no disrespect to Ms. Ball's condition. Mm-hmm. It's just that this matter has been going on. One of it go back to 2016. We've had a few adjournments. Before
you go on, do I infer that you have no questions, for example, to challenge the tenant's assertion with respect to Ms. Ball's inability to participate? In that you went right to submissions, do I assume, or do we assume, that you have no questions, that you're not challenging the validity of whatever health circumstance may impact her ability to participate?
That's correct.
Okay, so you're not contesting her inability to participate, is that correct?
That's correct.
Okay, one second. Okay. All right. So before we hear from you in response submissions, we just have some questions for clarification. So, Mr. Bosch and Ms. Ball, any prospect of Mr. Bosch, you proceeding in Ms. Ball's absence if she's not able to functionally participate?
I'd like to, Mr. Chairman, but I'll need her participation to present the case.
Why?
I'm sorry?
Why?
She's a witness, an integral part of everything that happened. We're each other's witness in many of these. I'll need her to authenticate some of the recordings that I planned on presenting. Also to catch anything that I miss. I depend on Ms. Ball to help me with that.
Do you anticipate that she's privy to information that you don't have through your own direct knowledge?
Yes, quite a bit. She had many interactions with our landlord and his brother, Agostino, that I wasn't there for.
Bear with me. Interactions pertaining to issues germane to the applications?
Yes, sir.
How about with respect to the landlord's application? Now, I'm assuming that this, I don't mean to assume, do I infer that your statement that her knowledge with respect to these claims relates to your 3 applications, or does it also relate to elements of the landlord's application?
All 4, I'm afraid.
You're afraid? How so with respect to the landlord's application?
I'm sorry?
How so with respect to the landlord's application?
The L2?
Yes.
They have, Ms. Ball was alone one of the days in the apartment, one of the days that our landlord is claiming that he was harassed and interfered with. I can't speak to that directly because I wasn't there.
All right. At this stage, at this stage, do you have any medical? Is there some medical circumstance that has been diagnosed with respect to Ms. Ball?
Yes, Ms. Ball suffers from migraines and PTSD. A letter from her doctor here.
How many copies do you have?
3. Please bear with me, Mr. Chairman. I'm not used to working with paper at all.
Oh yeah. Okay.
So I may be a little slow at this. Actually, that was introduced one of the letters was introduced into evidence in the L2 application. So that should be in there. That would have been a note from Marie's doctor.
Well, we're not going to ferret through the board's files with respect to this particular issue. We're now dealing with a unique issue concerning your request for an adjournment. The expectation is that you produce documents, whatever you have in your possession, in support of that afresh.
There is one of them.
Keep rising. Ms. Knack, give me a copy, and we'll take a copy as well. Thank you so much. All right. So this is what is this? A prescription?
No, that is a note that Ms. Ball's doctor wrote for her to indicate that she is under a doctor's care and indicating.
So it's written on a prescription pad, August 3rd, 2017, Lauren Woods, MD.
Yes, there is another.
I'm just reading it. With your permission, I'd like the opportunity to review this aloud for the record.
By all means, sir.
Okay. For Marie Ball, the above-mentioned patient is under my care. She has a, what does that say? Dysthymic disorder and borderline personality trait and PTSD. Sorry, does that impact the need for the adjournment? I thought you said she was simply physically ill.
I'm sorry?
Right now, we were simply inquiring as to whether there are any diagnosis or documented medical circumstance that has created the symptomology that you assert today.
Yes.
This letter with respect to this thank you. This letter on PTSD, does that impact the challenge he's experiencing today, or is there something else going on?
It's migraines, sir.
Okay, does that relate to this letter is all I'm asking you?
The migraines and the PTSD are in combination. I'm not sure how to explain this.
Well, I'm simply asking for medical support. You're not offering medical support. You're not testifying as if you were a healthcare practitioner, right?
No,
Okay.
I'm testifying based on my experience with Ms. Ball.
Okay. You said you had some other document?
Yes, sir.
While you're looking for it, we'll recess briefly so member Glenn Copeland and I can have a brief word. I won't deactivate the recorder because it is quite finicky. Don't say anything self-incriminatory. Thank you. Any luck, sir? If you can't find it, then we'll live with what we have. I'd like to get back on record.
Folders missing.
All right, thank you so much. If you don't have it on you, then I won't put you to an impossible onus. All right, do you have any questions and clarification for the tenants? Member?
Well, you said that from your own observations and experience, having lived with Ms. Ball for quite a few years now, you know that vomiting is usually associated with her migraine episodes?
Yeah, those are the bad ones that she can't work through. When she starts going up, that means she's not going to be functional in about an hour.
Okay.
Anything else, ma'am?
All right. Is there anything that can be done to alleviate the symptoms
Quiet
and
dark.
enable her to function?
Quiet and dark for
Quiet and dark.
as long as it takes.
I see.
That's usually longer than the hearing aid will last. I wish it were otherwise. Believe me.
Anything else, ma'am?
All right.
Before I might just have another question. Do you have anything else in your questions of the tenants? All right. Is there anything else? So I'm going to ask just to be absolutely certain. Certainly, Ms. Ball's physical appearance, in that she's doubled over on the desk moaning, is certainly suggestive of an inability to participate on the face. But specifically, what would she not be able to do here today because of her vomiting and migraine?
I'm sorry, I didn't quite catch that.
So would she be able to listen to what's going on and respond, or no?
Sometimes yes, sometimes no, but when her migraine gets bad, she doesn't fully comprehend what's going on
Okay.
around her.
All right. Thank you so much.
Is it an episode that lasts for, say, are we able to reconvene in the afternoon, you think?
I doubt this one's going to go away that quickly.
Okay. Fair question.
It's impossible to say ahead of time.
Okay. How long do they generally last, or is there an average?
One this bad, 8-10 hours would be my guess. Is that about right, Marie? Marie? How long do you think this headache will last?
Okay. Okay. Let's not put her to an undue onus then. Anything else you wanted to say in response to the questions put to you?
Nothing comes to mind.
Okay, thank you. Okay, Ms. Yakni, I think you kind of started us down the train with respect to the landlord's response to the request, given the lengthy history of some of these files, the landlord would be opposed, while acknowledging, or at least not disputing, the reality of Ms. Ball's physical circumstances today, right?
That's correct, sir.
Is there anything else you wanted to say?
In the event, Chairman Henry, if you were to adjourn this hearing, we would have to take into account that we've had previous episode where Ms. Ball was not well and we had to adjourn, so we would have to accommodate that possibility being a realistic potential at the possible next hearing.
Right.
In all fairness to the landlord. Now, the L2 application, you briefly touched on that. To my recollection, we had complete examination, direct and cross of witnesses, and the matter was adjourned in the August 10th hearing for submission and recording. That was admitted. So there is, on that file, it's...
I need to interrupt that, and I should have framed this out at the outset. It's a fair point you're making. The then vice chair of this region, who orchestrated the combined hearing of these matters, did so, as reflected in my interim order, if I'm not mistaken, that the matters would be heard afresh. In other words, without consideration of the evidence previously adduced. Because of their joined nature, I'm assuming the vice chair determined that the only way that these matters could be heard by way of a multi-member panel would be to have them heard anew. Bear with me a second. Anything in there?
So disclosure's been done. This is yours.
Just reviewing the board order, see if that's reflected therein.
Yeah.
Okay, so, thank you. So, Ms. Yetney, I'll refer you to the interim order by Member Dillon Culp and myself dated July the 11th. The paragraph above it is ordered that paragraph, or line, I'll read it. These applications are really scheduled to be heard on different dates before two adjudicators, Member Henry and Member Leon Culp. However, it appears clear that there may be significant substantive overlap between the applications. With this in view, and in the interest of judicial economy, administrative efficiency, consistency in board decision-making, and the convenience of the parties, the matters have been scheduled to be heard together, afresh, by a panel consisting of these members. So that was the indication in the interim order.
I stand correctly, Member.
Thank you, ma'am. And in fairness to your point, though, ma'am, this is a very rarely invoked circumstance. In fact, in my years of doing this work, I don't recall ever having been part of a panel except during the training phase that I undertook many years ago. So we're in curious waters here. Anything else, though?
That would be our own position in the event that this matter is adjourned today, that we would request the board consider an option that a hearing could proceed in the event that Ms. Ball do have a physical illness.
How could we assess that in advance, though? I guess that's what you're asking. You want us to kind of contemplate a framework by which the matter would proceed irrespective. Now, the nature of her health circumstance today, seems quite clear, prohibits her involvement in the proceeding. A party has a right to participate in a hearing. I don't know how in advance we can make an order other than the usual peremptory wording, but of course, as we all know, that term means absent extraordinary circumstances, there is a high expectation the matter will proceed on the return date. It is still open for either party to establish that a threshold has been crossed by virtue of physical circumstances or otherwise.
And Chairman Henry, if I may just add, in good faith measure, it is my hope that the tenant, Mr. Bosch and Ms. Ball, can have a discussion with regard to that possibility and have some submission as to how we should proceed in that event.
Right. I see your point. All right, anything else?
No, Chairman Henry.
Any questions of Mr. Appleby? Sir, any questions? The landlord is opposed to the granting of the adjournment. Do you have any questions, presumably to challenge that position?
Nothing that come to mind, but I would like to point out that we gave our consent for the landlord.
Okay.
They requested.
Thank you. Any questions of Ms. Acting Member?
I was wondering, I'm just going to explore this, if there's any possibility that we start with the landlord's application, allow examination in chief of the landlord, just so, because we've allocated this time for these matters. So I understand the situation, but I'd like to get some use out of the resources that have been allocated for today. Is it possible to start with the landlord's application and then set aside cross-examination for the return date? Is that a possibility? And in the meanwhile, we can send Miss Ball home.
Well, okay.
To recuperate.
One second. Before we even get there, member, with your permission, let's put a dog arrow on that.
Mm-hmm.
Before we start exploring even that element, I want to advise the parties that we've arranged for the availability of a mediator today. Specifically, having come to understand through board staff in the moment before this call of the hearing that Ms. Ball may or may not be in a position to proceed, we've undertaken steps to make a mediator available here today. Okay, here's the problem, parties. I'm going to sketch it out for you all. We want to give you all closure, one way or the other. We have a variety of applications, and the prospect of bringing these en masse back in the relatively near term is absolutely non-existent. Member DeLeon Culp and myself have dedicated a significant amount of time that we could otherwise have put to other matters as a courtesy to the parties to give you the best chance for resolution. We may or may not be able to do that today because of Ms. Ball's situation. It is what it is. But we do have a mediator. Now, Ms. Bosch, the value of the process in mediation is that, as you know, it is not an advocacy-based process where a party does not have to participate in the same way that they would when they're trying to advance or defend a case. Right? It is interest-based. Do you understand that?
Yes, I do.
Okay. Plus, it's done in a closed setting. It tends to be much more informal than a docket. And the kind of evidentiary and procedural framework that we have to apply in the hearing process is not an issue there, which tends to make for an easier go of it for parties. Make sense? You understand? First of all, you understand what I'm saying?
Yes.
Okay. So before we even go down the pathway of considering what we can or cannot turn our minds to here today, Ms. Rossiter is at the ready. We can bring her in here. Member DeLeon Culp and myself can step away. She can accommodate Ms. Ball as she needs it to the extent that she finds herself unable to participate even in the less cumbersome process of mediation. She can take breaks, she can do other things. But remember something, the adjournment framework is by no means guaranteed. An adjournment is by no means guaranteed. The simple asking of it does not magically create that opportunity, right? So before we kind of even go down any further route, any sense in our bringing Ms. Rossiter on board, see what can be done there?
Yes.
Ms. Yakney?
Yes.
Okay. So what we'll do then is we'll step away. We'll bring Ms. Rossiter here. Okay. Usually, as you know, you migrate to her office. We want to be able to afford you the comfort of the room. Okay. I see a bunch of people in the gallery. I'm assuming these are all witnesses or observers in relation to this matter.
Witnesses.
Okay. So Ms. Rossiter will handle presumably their removal until her process is concluded. But here's the deal. Here's what we're prepared to do. I'm prepared, and member of the on-call is prepared to hold in abeyance the other work that we have that we'd otherwise apply ourselves to this morning, such that if you come to terms, even partial terms, as those terms are arrived out, if they need our endorsement, Ms. Rossiter can come and get us in real time, and we'll endorse those terms as long as they're lawful. Does that make sense? In other words, the member and I have only one goal today: to help you as much as possible begin to put these variety of issues in the rearview mirror of your lives. For a number of reasons, not the least of which is, if the adjournment isn't granted, well, Mr. Bosch, you're proceeding here today in circumstances where you'd have me understand Ms. Ball is not at her best.
Yes.
Okay? And you're by no means guaranteed the request that you seek in terms of it being granted. If we don't proceed, Ms. Yakvi, well, you know the reality here. Today's hearing was a long time in coming. To join these matters again on a subsequent date might be many, many, many months down the road. I can't speak for member of the on-call, but my opportunity to carve out special time for the continuing consideration of matters in this format is extraordinarily limited. So your expectation with respect to near-term return, should resolve not occur today, needs to be managed downwards, because the member and I have given up our time here today. Is that understood? Sorry, do your clients have interest in the mediation process? I don't think I asked you. She said yes? I don't remember.
She said yes.
Okay.
Yes.
I was so busy in my soliloquy, I forgot what you said. All right, so we'll step away. We'll get Ms. Rossiter here, and good luck, parties.
Thank you.
We should turn.
Yes, I know. Back on the time now is 11:55. Hello, parties. You've attempted mediation?
Yes, we did.
Any outcomes?
I don't believe, but Mr. Bosch indicated to me a few minutes ago that he wanted to have a word with the mediator again.
Another word? Is that right, sir? Mr. Bosch? You want to continue discussions?
She's already turned down the offer, so there's not
Okay.
much point.
So that's
All
why
right.
Ms.
All right. So mediation failed then. All right. Nothing ventured, nothing gained. Now, Ms. Ball, Mr. Bosch, what's the status of Ms. Ball in terms of her ability to participate? Where are we?
She's not able.
Is she able to communicate to me? Ms. Ball, are you able to speak to me or no? Ms. Ball, are you able to respond or no? All right. Very well.
Mr. Chairman, I did
Yes.
find that letter from her doctor.
You okay? Do you have a copy for Ms. Naki?
Yes.
Thank you.
Thank you.
Does list the migraines.
All right. Can we read it aloud, ma'am? December 13, 2017, from Lauren Woods, MD, directed to my attention for some reason. Dear Sean, okay? The above-named patient has been under my care since 2004. Marie suffers from depression, PTSD, bipolar disorder, and migraines. These diagnoses can all be exacerbated by stress, for example, her housing situation. All right. Should you have any further questions in regards to this patient, please contact my office at the number provided. Okay. All right. So obviously, Mr. Bosch, I've inquired of Ms. Ball if she can respond to my engagement. She has not responded. She just continued moaning. Bear with me. So I'll turn to you. Has her circumstance changed since earlier this morning?
I'm sorry, I didn't.
Has anything changed for her since this morning in terms of her ability to engage? Can't hear you.
No.
All right. All right. And Dr. You earlier conceded Ms. Ball's symptomology today such that she could not participate in the hearing. That was what my notes reflect and my recollection sets out. Have I misapprehended that?
No, Chairman Herron, based on my the appearance, I'm
Yes.
not an expert.
Yes.
That's my...
Okay. So, okay. Bear with me. All right. All right. It strikes me, unless Madam Member, you have a different view.
No,
that there-
we've discussed, so
All right,
you
all right.
speak for both of
Okay,
us.
thank you. So our goal will be to adjourn to the next available date. We're going to set up some conditions, though. The board has directed significant resources with respect to today's hearing. We don't intend that we not be able to proceed on a subsequent date. Bear with me. Here's what we're going to do. I infer, Mr. Bosch, that Ms. Ball's migraine circumstance might surface at any point, perhaps an unpredictable point, such that who is to say whether or not she will be able to participate on the next date. We don't want that. We don't want her interest to not be represented here. So here's what you're going to do. And we're going to go ahead, heck or high water, the next day. It's a truly extraordinary circumstance. Now, we're going to direct you. Bear with me. Bear with me. You're going to have to be ready. If there is a risk, and there obviously appears to be a live possibility that Ms. Ball will not be in a position to participate in a fulsome sense by way of advocating a position, you're going to have to get ready. She's going to have to prepare you with respect, particularly with respect to those events that you say she was uniquely privy to. Do you understand that?
Yes, I do.
In other words, you ought not expect that a subsequent adjournment request will be granted simply on the basis of Ms. Ball's current circumstance. The board has a mandate to resolve things expeditiously. That has to be balanced against, of course, our even more important mandate to ensure parties' participation. But we're now oriented around the fact that there could be a risk that her engagement going forward may be jeopardized. She'll have to either deputize you or somebody else to advocate, specifically in relation to, again, those fact circumstances that are uniquely in her knowledge. Do you understand that?
Yes, I do, Mr.
Do you have any problem complying with that? I can't hear you.
Nothing I can think of, no.
You better not. You have several applications here. Here's what's going to happen, possibly. To the extent that you're unable to proceed on the next date around your applications, we may simply dismiss them. Dismiss them because we're hearing these, and this is something we might even engage today. Hear me out. Since we're conducting the hearing of these applications afresh, there's been no, in a legal sense, there will have been no considering of the merits of the application. You understand that?
Okay.
And if the merits haven't been considered, then it opens the door to make the argument that a fresh application can be considered in relation to those elements otherwise lodged in the present applications. Do you understand that?
I'm not sure I followed you,
Okay.
Mr. Chairman.
If a hearing were conducted on the merits, if a hearing were conducted on the claims,
Okay.
and a decision arrived at, then all things being equal, a party, the moving party, would likely not be in a position to have those claims heard afresh simply through the filing of another application. In other words, it's generally considered that each applicant gets one kick at the cat with respect to advancing their claims. Does that make any sense?
Yes, it does.
Okay. Now that prohibition, we call it res judicata in law, would apply generally when a matter had been considered. Once considered, the door closes upon a party perfecting its case by filing a subsequent application, right?
Okay.
One-shot deal. It's like having a gun with one bullet in it. Does that make sense?
It does.
All right, you get a chance to pull the trigger once. Now, if a hearing isn't considered on the merits, then it leaves open the possibility that that party could file a fresh application, given the fact that this principle of res judicata, this barring principle, will not have prevented that opportunity. Does that make any sense?
It does. Is that the situation here?
Not necessarily. It's something we're prepared to explore before the adjournment is functionally granted. But I just want you to understand that if Ms. Ball is unable to proceed on the next date, let's refer only to your applications, right? Your 3. Okay? And if by virtue of that you're unprepared to proceed with respect to those, the board reserves the right to simply dismiss them. And that opportunity is actually live here today. But shall we make that exploration at first instance?
Yes.
Do you want us to dismiss them, or do you want us to adjourn them, sir?
I would prefer that they be adjourned.
Why one versus the other? Why should we accept one versus the other?
Well, dismissing them, it seems to me that the 1-year limitation would...
And just to kind of touch on that point, that is a functional issue, and you're right, I should have mentioned that. The board maintains jurisdiction in an application of your type over remedies up to 1 year prior to the filing of the application in the normal course, but that's actually quite correct. Okay, so that's your opposition to the dismissal, is that correct?
One of them, yes.
What are the rest?
The other, I haven't discussed it with Maria. And I don't believe she's understanding what we're talking about.
Anything else?
Nothing comes to mind.
Can't hear you.
No, Mr. Chairman.
Ma'am, do you have any position one way or the other?
No, Chairman. I'm at your discretion.
Okay, all right. All right, so what we'll do, and my co-panel members, I think of this year as well, we'll put this over, hold this ball to the next available date. And just know something, Mr. Bosch, we're not going to have this going forward, this dynamic. Okay? Now that we are, you and everyone else here, and Ms. Ball, are apprised to the risk that she may not be in shape to proceed on the next date, she ought not expect that the result arising here today will simply be replicated on the return of this matter. The more a matter is put over, the more incumbent it is on the board to be mindful of the need to bring resolution. So if she can't proceed on the next date, she's going to have to empower you in advance. In other words, when this matter comes back, and if she's in a similar condition to what she is today, what I don't want to hear from you is, Mr. Henry, and Mr. still on the call, you know what? All of a sudden she became ill, she's not able to proceed, and this blindsided me and we can't proceed. We have today's history as a track record as to the risks. She's going to prepare you, she will have to prepare you or someone else with respect, especially to those factual circumstances uniquely within her knowledge, and you're going to have to present on her behalf or someone else will. Is that understood?
Yes, it is.
Now, the board, of course, maintains independent jurisdiction to make an appropriate decision as on the date, but I want to have you gird your mind around this interest, and we're going to set this out in an interim order. If she's unable to proceed, she's going to have to make alternative arrangements with respect to how her evidence will be adduced. Is that understood?
Yes, it is.
What's that? Was there something else? No. Okay, I just have a few more points. Okay, I'm making a note that I've alerted you to the risk of dismissal of your applications if you're unable to proceed on the return date. Do you understand what I'm saying?
I do.
Okay. Now, if on the return date she's unable to proceed, or you are, or whatever, or she is unable to, because of this issue, there is a possible risk that you will face board costs with respect to this if you have not adequately prepared in advance of this risk. Does that make sense?
Yes.
Okay. Board costs, when awarded, and if not paid by an applicant, prohibits that applicant from advancing its application until the costs are satisfied.
I'm aware of that.
Okay. I didn't know if you were aware, so I thought it incumbent on me to inform you of that, okay?
I appreciate that. Mr. Chairman, there is another circumstance you should be aware of.
Please.
I also suffer from migraines.
Okay.
I'm very seldom unable to function, but it does occasionally happen.
Well,
what happens if we
then you'll make proper arrangements as well. Here's the thing, and I'm glad you told us that. what you've advised me of and what I'm aware of here today at this point, what we're aware of, is that there is a reasonableness of forethought around the risk. This is not the same situation as if somebody fell under the bus on the day of the hearing, an entirely unpredictable circumstance that no one could guard against. Now you've advised us, Mr. Henry, I am also at risk that migraines might impact my ability to engage. Well, you're going to have to do the same thing. You're going to have to, if you can't, here are your choices. You bring someone to assist you in this regard, to advocate on your behalf. You apprise them as to the fact circumstances you intend to reduce into evidence so they can present that. Remember, the board has the opportunity under the Statutory Powers and Procedures Act to receive hearsay evidence. We're not barred as a court might be, and more generally a civil court, with respect to those elements. Actually, we are authorized in law and in fact required to consider any fact or thing adduced into evidence. Everything comes in here. It just goes to weight. Do you understand that?
On the last part, I don't quite follow.
Okay. We have the ability to consider anything.
Okay.
If it's hearsay, then that's one of the hearsay nature of evidence might cause us to assess an appropriate value to attach to it in terms of how much weight or credibility we give to it. Does that make any sense?
It does. If I understand you correctly, you're saying hearsay generally goes in the garbage.
I didn't say that at all.
Okay.
Okay.
I
What's that?
misunderstood what you said.
Okay. Go ahead.
I think, correct me if I'm wrong, what Member Henry is saying is that we have the ability to receive hearsay evidence, but we will accord the appropriate weight to it. So if there's direct first-hand evidence and hearsay evidence, we can choose to give more weight to direct first-hand evidence as opposed to hearsay evidence. So we accept hearsay evidence, but we will accord it the appropriate weight based on the context of all the evidence that we receive.
The weight just refers to the value we assign to it as something that we can that we consider in our deliberations. That's all it means. It doesn't mean it goes in the garbage. It means that we're authorized by law to receive hearsay evidence. So the mere fact that the deponent of that intended evidence isn't present at the hearing is not a bar to our considering it. In fact, we receive hearsay evidence all the time. So if either you or Ms. Ball find yourselves, because of these migraines, in a position so as not to be able to advance whatever your response might be to the landlord's application, then now that we know that this risk is live, and because Member Leon Culp and myself will be on these matters going forward, I will be entirely interested in understanding, if that circumstance arises, why you haven't made appropriate preparation. Do you understand that?
Yes, I do.
And you may not find us entirely sympathetic there. Do you understand that?
I have no doubt of that.
Okay. One moment.
Thank you.
All right. So, okay. And again, as it relates to your application, and I want to reiterate this because it's quite important. And you know what? We've said a lot here today. I want to make sure that the weight of it kind of flows to both parties. I'm referring specifically to the landlord's application. What Ms. Ball's circumstance here has done, fundamentally, was delay the consideration of the landlord's application against the landlord's will, presumably. Okay? So that's really my focus here. If you're not able to go ahead with your applications for whatever reason on the next day, the time is coming now we're going to consider the prospect of dismissal, which, as I indicated earlier, is not intended to be a ruling against the merits of the claim. Is intended to simply set out that we can't proceed because you're not prepared to prosecute the application. And the board does not contemplate a continuous revolving door circumstance of adjournment. One tool that we will access in appropriate circumstances is dismissal. Do you understand that?
Yes, I do.
And that's without consideration of the merits. All right, so let me think.
I'm sorry, Mr. Chairman, I didn't catch the last thing you said there. That's without...
Without considering the validity of the claim. In other words, it's not a ruling that the claim is without merit. Okay. It's a simple kind of administrative dismissal because where we haven't considered the merits. Does that make any sense?
It does. I just didn't hear what you said.
I understand. Let's see here. Okay. So, anything else, Member? All right. Just give me one more moment, please, parties. I'd like to recess very briefly and confer with the with Member Leon Culp. We'll be back in a moment. get back. Thank you for the indulgence, parties. The tenancy is still ongoing, is it?
Yes, it is.
Ms. Nagi, in relation to the landlord's application, is there anything of special urgency that would give us cause to bring these matters back on a more expedited basis? I'm going to ask the same of you in a second, sir, but anything from your end?
Just that the issue, the landlord would like to have it resolved.
What's the issue? Which issue?
With the access, that was one of the events that led to the N5, and the landlord continued to have issue with accessing the unit. So,
is there a concern, not to enter the merits, but just so we can sculpt more precisely the terms of an interim order, is there some concern with respect to ongoing denial of access to the unit, either party?
if Mr. Bosch would agree to allow the landlord access, I think that would facilitate us
All right.
being in a better position.
Mr. Bosch, without making a decision with respect to the historic claims around alleged denial of access, putting that to the side for a moment, so we can kind of maintain a kind of functional status quo in the interim. And again, this is not making a ruling one way or the other with respect to any of these claims. If a landlord seeks to gain lawful access, in the meantime, and you may or may not know the circumstances under which they may be able to obtain access in law, but can I outline them for you quickly? Right. From what you told me earlier, I understand, of course, I infer you have a general understanding as to the legislative framework. With your indulgence, can I just speak with you briefly?
Please.
Okay. A couple of circumstances. One, the landlord can gain access without notice in an emergency circumstance. Two, the landlord can gain access on consent of a tenant when that consent is given at the time access is attempted. And three, there are various circumstances under which the landlord must give notice. Now, are these inspection notices, Ms. Natvi, other notices, maintenance,
Yes.
repair? Okay.
Yes.
So the landlord serves notice at least 24 hours before access is attempted, then for maintenance purposes, right? Then the tenant has to comply, right? Now, we don't know the reality of any of these claims lodged in the application. So without rendering comment or judgment with respect to any of those claims that will be eventually adjudicated, if we included a provision requiring you to not interfere with the landlord's efforts to obtain lawful access, do you have any concerns there? I'm talking about in the meantime.
I do.
What?
We've asked Mr. Serino, actually beginning in March of 2017,
Yes?
to accommodate Ms. Ball's mental illness by not attending the apartment in person. His behavior is extremely antagonistic and triggers migraines for her.
So if the landlord would send, now not entering the merit, but the landlord would send an agent to undertake whatever activities.
Asking for that all.
1 second. Is that the? And we're talking about the interim right now.
For the interim, I would have to discuss with Mr. Siren. Some of the repair has to be dealt with by himself.
So what I'm hearing is that we can't sculpt the interim terms. I'm only doing this, or we're only prepared to go down this route in order that the alleged let me step back. There are statutory rights and opportunities that, irrespective of the claims lodged in the applications, must be respected going forward, at least in the interim. Now, from what you're telling me, the parties cannot. You're telling me that the landlord has to gain entry personally for some reason. Is that right?
If in the event that for certain repair,
Only he can do them?
he is the one that determined what needed to be done. He don't have, so he works with his brother and another superintendent. They don't have the ability to do those repair without his assistance or his direction, and
So
that
no,
has
okay.
been the pattern.
Well, we'd only be prepared to institute terms that actually track the statutory landscape. The statute, of course, permits the landlord to gain access, and inferentially the landlord's agents. But I think what the tenant is saying that there's something in the relationship there that impairs the tenant's, at least Ms. Ball's, health circumstances. I do need you to understand something, though, sir. Okay. We have no authority to override the statutory framework. If there is an issue pertaining to the interaction between the landlord and Ms. Ball that has an impact on her health circumstances, then an accommodation feature has to be structured if we come so far as to make that determination. But as it relates to barring the landlord's access, we cannot override the law. Do you understand that? The most we could ever do is set out that the landlord shall not interact with the tenant in a manner that exacerbates her health circumstances. But under no, first of all, so that's very important. Query, and I don't want to step into the merits of the application, but we want to give you all some interim satisfaction. So whatever exacerbations occur between the two of you won't escalate in the interim. That won't help anyone, because we're not coming back on this likely for several months. Then were you content with this engagement?
Yeah, I was just wondering, as part of exploring interim terms, whether we can sculpt something whereby the landlord himself can attend with his agent and or his brother, while Ms. Ball is not in the unit.
Well, okay.
Something like
Parties, look, here's the thing. That's fair enough. We're prepared to hold this down for a couple of minutes. Now that the adjournment is in the cards, here's what we don't want. I don't want. That when we come back, we have additional concerns running in the interim. That won't help anybody. Okay? You want to take a couple of seconds to see if you can construct interim terms that meet your respective interests around the landlord's access to the unit for maintenance purposes. Would that interest you, Ms. Nucky?
Yes, that would be agreeable.
Okay.
Thank you.
Now, would that interest you?
Yes.
All right. Now, on your end, I wonder if there are any interim terms we can turn to support your interim satisfaction. What are the essential nature of the claims in your applications? What are the nature of the claims in your applications?
Which one?
You tell me.
Okay.
Which ones can we kind of structure something in the interim around? Any ongoing activities, ongoing behaviors?
T6 are maintenance issues, like we have asked for repairs since.
Now, we can't give resolution on an interim order to those elements, but for the consent of the parties. Bear with me a second. Exactly. On the hearing of the T6, the maintenance issues, can we anticipate in an interim sense gaining some resolution around rectification of those deficiencies, or the landlord would be, for example, contesting the reality of those claims?
If I understand correctly, in our discussion earlier, there's two remaining issue that's pending. The bedroom carpet and the front door has been repaired, but it needs some further work. Those are the two issues that remain.
And that the landlords are prepared to admit to as an outstanding maintenance disrepair? Okay.
Excuse me, sir, that's not quite correct. There was also two windows that have holes in them.
Okay, fair enough. Whatever those issues are, query. While we hold this down, we could also explore with you, we could allow you to explore when, if at all, you can agree that those issues will be rectified to the extent that landlords are prepared to admit to those issues. We still have, of course, abatement and monetary claims hanging in the background. But if we can bring to closure some of these ongoing issues through an interim order, that might help you both. Any sense in that discussion as well?
Yes, that would be helpful.
Okay, good. What are your other claims of an ongoing nature?
Harassment.
What does that mean?
Harassment.
What does that mean?
Conduct
Pardon?
that he knows or not to know is unwelcome.
Like what?
Screaming, making mocking gestures,
Okay.
grabbing our possessions, smashing ladder.
Okay, so here's a question. These things don't have to constitute admissions as to misconduct. But I'm wondering if in your discussions, if you want to talk in the interim around how the landlord communicates with the tenants and certain prohibitions around the nature of that communication, just to keep things level in the interim. Any interest in including that part of the discussion without them constituting the admission? Certainly the repair issues would have to be a functional admission of disrepair for them to be addressed.
No, Chairman Henry, I agree. I think it will be helpful. I have the discussion with my client. However, I think I'm not opposed to having that discussion.
Sure.
Again, if it would help.
Very good. And if their agreement is arrived at around behavior, it doesn't have to constitute an admission that those behaviors took place. This simply governs the here and now until we come back, so that we're not dealing with issue upon issue on the return. So yeah, we're going to have that discussion. What else? What other concerns are there?
The coercion is.
I'm talking about ongoing concerns.
Ongoing
Not the historic stuff. The historic stuff we will uniquely address in the hearing of the applications. What we're talking about is there anything that is ongoing in the here and now that runs at risk of recurring before we come back, that the parties can gain some management of in the interim? Is there anything else?
Well, his brother Agostino has been doing the repairs since January, so there has been no conflict.
Oh, good. Okay, good.
As long as John doesn't come to the apartment, there's no conflict. There never has been.
Okay.
It's only when he's there.
Okay, so I wonder, here's the thing, bear with me. We wouldn't have the authority in the hearing of the application, if we sound in favor of the claim around the landlord's misbehavior when he entered the unit, to prohibit his access to the unit. The law doesn't allow that. Our scope of authority does not exceed the law. All we could ever do is require that he not misconduct during his exercise of entry into the unit. I'm wondering, is there any sense in having a discussion that should the landlord enter the unit or attempt to gain entry for some lawful purpose, that he will abide by certain constraints?
And I intend to have that discussion
Okay.
with regard to his conduct
Right.
and interacting with.
Fair enough,
the
fair
tenant.
enough. In which event, sir, a query then. You see, you don't have the authority in law to bar the landlord's entry. I want you to know that. It doesn't exist. Now, we're wondering, in the event that the landlord is prepared to consent to certain restraint on his behavior during his access, then I would infer that you would be prepared to engage in to set out in an interim order that you wouldn't prevent his access. In other words, parties, here's what we don't want. Here's what I definitely don't want. We have a lot on our plate examining the issues set out in the current applications. Nobody wants them to exponentialize in the interim. This is not what I'm prepared to indulge. So, if the landlord is prepared to, if you and the landlord are prepared to sculpt out prohibitory and kind of forms of interaction, right? Yelling, screaming, whatever it is. Presumably then, with that context in view, I infer that you would be prepared to not bar entry, subject to any his deviation from that. What do you think?
It's what we told him all along.
Okay.
Days, he's welcome.
Here's what we're going to do. We'll hold this down. You see, parties, here's the thing. I suspect that on the return, we need to start focusing on the merits of each without encumbering ourselves around the ongoing matters. Why don't we hold this down, see if you all can have a discussion around notching out a framework of expectation around the going forward until these matters are brought back on all issues that have a going forward proposition. Let us know when you're ready to go ahead. Let the commissioner know. We'll come back in here and we'll sculpt those terms in an interim order. Is that fair?
It's fair.
Thank you so much.
Thank you.
All right. Buddy, back on record. Parties get a chance to confer on prospective interim terms.
Yes, Chairman Henry, I've spoken with the landlord,
Yes.
and I've spoken with the tenant, Mr. Bosch.
Thank you, ma'am.
We are in agreement with regard to the three issue that's outstanding, the bedroom carpet.
Right.
There's a dispute on the amount of carpet that need to be installed, so that's subject to inspection, and the
Okay.
landlord respond to that.
So what's the landlord going to do? Do something with the carpet? Replace, repair?
I can replace,
Yes,
Replace? So landlord shall replace?
but I need to go in there to do it.
yes, so
Okay.
it would be subject to an inspection and then subsequent repair.
So which bedroom are we talking about?
It's,
Bedroom 3 on the diagram.
I don't know what diagram you're referring to. Without a proper characterization, 3?
when you go in the front door, it'll be the first bedroom you hit.
Okay, well, the tenants have me understand that that's characterized as bedroom 3. Do you both have a common understanding as what bedroom that is?
I don't know either. I assume because he handed out a sheet saying which bedroom 1, 2, 3.
Are you both on the same terms as to which bedroom we're talking about?
I think I am.
You walk in the door immediately to your left through the hallway.
Yeah.
Okay.
First bedroom you hit on the.
Okay, so we
Bedroom
are,
3.
It was Mike's room.
Correct.
It was Mike. It was a previous tenant living with Mike.
All right.
and the other issue is the front door. There's the tenant indicated there's a gap under the door. The landlord is going to look at it and
Okay.
to repair.
So, but can I just interrupt? So that's going to replace the bedroom, the carpet, right? Carpet in bedroom 3.
Yes.
By when?
It'll take, I'd say in a week, maybe give me a couple of weeks.
Well, suggest a date, party. Suggest a date that was
Within
agreeable to.
within a month.
I would like a date that is agreeable to the two of you, please.
Okay, because I gotta
October
make.
30th.
What's the
October
date?
30th?
Yeah, October 30th, day before Halloween.
So what's today? Yeah, okay, it's over a month.
October.
But that's conditional upon me being able to get in with
I think
them.
we'll be turning our mind to those other circumstances
I don't want to be
momentarily.
hindered.
I understand. Okay, October 30th. The next issue there, ma'am?
The front door, there's a gap under the door.
Right.
And it will be the same time frame, so there will be an inspection and then probably subsequent repair.
So landlord shall kind of remediate the gap, right?
Yes.
At the bottom of the front door?
That's
that what we're talking
right. Of the apartment.
Bear with me. By October 30th again, you say?
Yes.
All right. And that works for you, sir?
Number 3, on
that right?
two.
Yes,
Thank you.
On two windows, the tenant has indicated there's hole in the caulking, so the landlord will address that within that same time
Oh,
frame.
lovely. Landlord shall caulk, right?
Yes.
Sorry?
Apparently, I think there's a gap in the carpet. There's a
Shall
gap.
caulk
Yeah, it's about a quarter-inch gap, about 3 inches long. But
Okay,
it's
so
gaps in, which windows, do we know?
I don't know, I will have to go in and see the
But it was
windows.
2 windows, right?
Bedroom, or sorry, kitchen and bathroom.
Okay, in the windows, in
Kitchen.
the kitchen
And bathroom.
and bathroom.
There's only one window in each room, so that's...
Okay, all right, and that's by October 30th. Alrighty.
The landlord had also put forward made an offer with trying to help, elevate the issue with aggravation. And with regard to the notice, he's agreed that when he has to do an inspection, the notice will state that he will be coming to give Ms. Ball the opportunity if she wants to leave. If not,
Oh, the notices of entry will specify that he personally will be in attendance,
will
so she
be.
can make the election. Is that right?
yes.
I'll be there with my brother. Like,
But then whether you come with others,
Yes.
I think what you're saying is that the notice will specify that you'll be there,
Yes.
whomever else may be coming,
Yes.
so that Ms. Ball can figure out how to manage her time there. Is that right, sir?
Yes.
All right.
And
Okay, wait a
Also,
second.
also with the carpeting, because I need a larger window of time to do the carpeting.
Landlord shall, in notice.
And the notice will specify date and time. And
The normal bells and whistles, though, won't
Yes.
it? Am I being asked to? Are we
No.
being asked to go beyond the statutory requirement there? or
No.
Okay.
Actually, a specific room that he'll be entering, please. In the notice, specific room or rooms.
Okay. Verse. Sorry. The
oh,
notices-
there's three.
Sorry, let's just
Three
note this up.
rooms.
The notices of entry shall specify the specific room the landlord intends to inspect or repair, or is that one? That's one feature, right?
But can I put those all in one notice? That I'm going to do them all on the
It's
same
just a
day?
letter.
All on the same day. I don't want to come back 5 days to do
Yeah,
the
you
same
could,
job.
that's-
Well, the law doesn't prohibit any.
Okay.
It doesn't set out that kind
What
of
he,
stuff.
what he wants to do is he wants to maintain me from going to one room and then stopping me completely and come back another
Well,
day.
presumably, you could set out in the notice which several rooms you would intend
Absolutely.
to access for that
Absolutely.
date, and the law doesn't prohibit that. Do you have any concerns there?
Only that if he says he's going to, intends to enter it, that he actually does enter that room. We've got notices from him that cover the whole apartment, so.
Well, okay. Now, remember, bear with me a second. We're prepared to sculpt this in any manner that suits the parties, but we have to recognize the statutory framework as well. The statute does not require a landlord to identify which portion of the rental unit he intends to access. So what we're doing now is just going a little beyond that for the comfort and convenience of parties, but you have to understand there's no statutory requirement there.
Okay.
This is a gratuity that the landlord is extending to you in terms of the particulars he's prepared to identify in the notice. So we can't push too hard on that. Does that make sense?
It does.
Because there's no law behind it. There's only courtesy.
I don't have the room numbers. I'm going to put down the 2 rooms that require caulking.
Okay.
Because I don't have
Okay. The notices of entry shall specify the specific rooms in the unit that the landlord intends to access, right?
And the last.
Oh, sorry, I haven't finished.
Oh, sorry,
sir.
sorry.
And shall identify if the landlord personally intends to enter. So Ms. Ball can determine whether or not to be present. I guess that's the intention. Is that right? Or determine.
Not sure how to phrase that.
I mean, is that the intention? What's the value of the landlord identifying whether he personally will be in attendance?
It's not a surprise.
Okay.
Okay, I understand that doesn't make any sense. but
So Ms. Ball is aware. Well, there's a reason behind it, though. You're saying there's something about their interaction that negatively impacts her, so that she can take appropriate. So she can. I don't know. Let's leave it alone. I'll leave it be. Just whether he'll personally be in attendance. All right. And there was something else?
Yes, Chairman Henry. Also, the landlord has agreed not to have any direct interaction with the tenants, speaking to them directly.
Gotcha.
He would always have his superintendent or his brother with him, and if he needs to inform them of anything, he will have that message relayed through a third party.
I quite understand. Pards, you know what? We're really glad that we took this time for you all to have this discussion. I think this is doing a lot of important sculpting.
But if
Right.
if Mr. Ball talks to me, and Mr. Bosch talks to me, I will respond to him if he talks to me. I won't respond to Marie.
How about that? How
I will
about
respond to-
the landlord shall initiate communication
Just
with
between
tenants
me
through
and Bosch.
only through agents? Is that a?
Yeah, but I will only talk to Mr. Bosch. I'm just telling you, that's the person.
Okay, so is that what we're doing now? So we're changing that a little bit.
This way, there's no interference whatsoever that he says.
Okay. So is it about? Is the landlord expected to be able to speak with Mr. Bosch directly, or only Mr. Bosch?
I will speak only directly to him or through my brother, but if he
Okay.
speaks to me, I have a tendency to return the conversation.
Okay.
You understand me?
Yeah.
But I will not talk to Marie whatsoever.
All right. Landlord shall initiate communication with Mr. Bosch. Given name was what? Paul?
Paul, Peter, Paul.
Peter.
Only not. All right. So if Ms. Ball initiates communication to you, you're saying that you'll
I'll
respond.
talk to one of my representatives to tell her to not communicate with me.
Because the issue has been, there's been an issue between Ms. Ball and...
I get it. I get it.
To avoid that.
Landlord shall only communicate with Peter Bosch.
Or through the agents.
1 second. One second. Oh. All right. Can only communicate directly. Okay. Any contact with Ms. Ball shall be either in writing or through the landlord's agents kind of thing? Is that what we're thinking?
That's correct.
My
I
agent.
can't hear you.
Yes.
Okay, the reason why you have to articulate a response is that the audio recording doesn't capture your gesticulations. Make sense?
Makes sense.
All right, I want the record to reflect your views here.
I can respond to her through my agent. If I have a worker with me and she's in...
That's-
if that
I
would
think
happen.
that was your
That's-
intention as we got you set
I
out.
just don't, okay.
Okay. In writing or by agent, is that the intention here?
Yeah, by the agent it would be.
Okay, anything else?
No, that's all, Chairman.
And so does that work?
Yes, it does.
Okay. You know what? Actually, I want to say I'm actually quite impressed. The group of you put your heads together and structured a framework here that will govern your interaction, hopefully successfully, until this comes back. I'm quite impressed by this. This is good. It shows we all can speak with each other logically and reasonably, at least to gain partial resolution. It's encouraging. All right. Let me recite those terms to make sure they've been captured. All right. So I'm adjourning this to the next available date. I'll say peremptory on the tenants. And what that means, sir, Mr. Bosch, heck or high water, absent extraordinary circumstances, we're going to go ahead, whether or not you feel ready. All right? Now, all right. And you're going to be prepared to argue the entire case if Ms. Ball is not available, you or an agent, or something like that, all right? We're going to frame some proper wording, but the intention will be that recognizing the live risk that migraines might surface in a way so as to frustrate your advancing your case, you're going to have to get something else going on here. Make sense? Either hire somebody, bring a friend, bring a family member, whatever it takes to step in your shoes for the purpose of moving the ball forward. Does that make sense to you?
Yes, it does.
Okay. Do you have any concerns there before I finally endorse that?
None come to mind.
Okay, good. All right. All right.
Could I-
Yeah, absolutely.
Marie, did you hear?
Chairman, if I may just start, and that would apply to both the tenants in the event that Mr. Bosch is having a headache or he's not able.
Right.
Okay.
Yeah, good point, ma'am. I'm going to make a note to that effect. Sorry, what you say?
I didn't quite get it.
Well, fair enough. In any event, we'll set this out in an interim order. I'm going to require it in any event. I just thought to ask your submissions if in the event there was something that I'd missed. But we need to start moving the ball forward. Now that we know that there's a risk of the migraine reasserting itself, you have to take proactive steps, on both of you, to make sure that you're able to engage the process through a surrogate. Make sense?
Yes.
All right. All right. Now, I want to set out that the risk of dismissal of your applications is live in the event you're not prepared to go ahead the next time. I'm not saying that will be that will occur or not, but I need to set on record that you have been informed that that risk exists. And hopefully that will be a goad to give you impetus to take appropriate alternative steps to advance your claims. All right, now, that's the part that's being imposed. On consent, the landlord shall replace the carpet in bedroom number 3 by October the 30th. The landlord shall remediate the gap, right, at the bottom of the front door of the unit by October the 30th. The landlord shall pop gaps in the windows in the kitchen and bathroom by October 30th. All right. The landlord's notice of entry shall specify the specific room or rooms in the unit that the landlord intends to access. Bear with me. And shall identify if the landlord personally intends to enter, okay, or by agent. All right. I'll put in my notes, because of interpersonal challenges between them. The landlord shall only communicate with Peter Bosch, not with Marie Ball. Also, any contact with Marie Ball shall only be in writing or by agent. Have we captured the terms?
Yes, you have Chairman.
Thank you, ma'am. Sir?
Yes.
All right. So, here we are. Here's my thinking. Because you have both successfully, and we've done nothing, the member and myself really done nothing. The two of you have put your heads together around this. Because we sculptured terms to govern the interim that will prevent, hopefully, a continuation of the alleged challenges, it can afford us to kind of put, to sculpt this out into the future in a manner that is mindful of our respective availability as members. What we're going to ask you to do is provide unavailability dates for the next 5 months. How long do you need to do that?
I would need 1 week, Chairman.
Absolutely. Sir? So in other words, we're going to ask you, and I think we did this before, to fax to the hearing coordinator of this region dates for which yourself and Ms. Ball will not be available for 5 months, because I don't know when this is coming back. How long will you need to do that? Take them Ms. Daphne needs a week. Will a week work for you to figure out your schedule?
We do it right now, any Wednesday. Marie's not available. Other than that, we're good to go.
Oh, okay. What's happening on Wednesdays?
Ms. Ball volunteers for a group of...
Well, okay. I'll put that in my notes. I'm going to suggest to you that her interest in completing her volunteer activities weekly will not trump Member Leon Culp's and my availability should our schedule coordinate. Everyone who comes here has given up something in their day. Our goal is not to make this process so pain-free for parties that hearings are conducted only in circumstances where people don't have to put over agenda items for the day. That's not how this works.
Okay.
Sorry, what was Ms. Ball
She's
saying?
saying migraine doctor. She also has
Oh.
migraine doctor.
When?
Wednesday.
Every Wednesday?
That's his.
Okay.
That's his day for scheduling appointments.
All right. Oh, here's what I want as well. I want something from her. I want, bear with me. I want to require her on the next day to present medical documentation in support of the symptomology. Actually, we don't even have to worry because the landlord has actually acquiesced to the claimed symptomology related to the need for an adjournment. So that's not even being posed. So I won't put that to her on the return. But I think it's important. Let's see. No, it's not. I don't think that's needed, right? Because the landlord's not contesting that Ms. Ball's medical condition negatively impacted her ability to participate today. So there's nothing here to prove as it relates to the day. Is that a fair understanding?
That is fair,
All right.
Chairman. We also have that provision that if she's not feeling well, that there will be...
Right. She'll make arrangements. Right?
So we're satisfied.
All right, fair enough. Okay, Mr. Bosch, I won't put you and Ms. Ball to any other onus there. Okay? Any questions administratively before we let you all go?
No, Chairman.
Thank you very much.
Thank you. Sir?
No question.
All right. You know what? Let's make it the next 6 months. Just out of the abundance of caution, okay? I just want to make sure that we can coordinate this with our respective schedule as members. Bear with me. Well, thank you for your patience. We'll see you here again. We'll have a new notice sent out within the interim order. Take good care.
Thank you.
Thank you. This hearing is adjourned.